A very good afternoon, distinguished members of the Arbitral Tribunal, respected guests, participants, and members of the audience. On behalf of the organizing committee of the 9th Victor's Moot, I warmly welcome you to the final round of the competition. Before the proceedings commence, it is my privilege to introduce the members of the Arbitral Tribunal this afternoon. The presiding arbitrator, Mr. Chanaka De Silva, President's Counsel, was called to the bar in 1986. He is considered one of the leading legal experts in project finance transactions and negotiations in Sri Lanka and in the fields of litigation and alternate dispute resolution. He is a founder partner of Nithya Partners and heads the project finance and dispute resolution practices of the firm. He commenced his legal career as a state counsel in the Attorney General's Department of Sri Lanka, where he served during the period of 1987 to 1996, prior to forming Nithya Partners in 1997. For almost 40 years, Mr. De Silva has been involved in advising, negotiating, and structuring major infrastructure projects in Sri Lanka, spanning a multitude of sectors such as electricity, telecommunication, petroleum, roadways, ports, and mining. He advised on structuring and implementing many public-private partnerships in Sri Lanka and was also the legal advisor in several major privatizations of state entities by the government of Sri Lanka. Mr. De Silva continues advising the government, the private sector, and lending institutions on such transactions up to date. Since 2010, Mr. De Silva has been consecutively ranked as a leading individual in the field of projects and energy and dispute resolution by the Legal 500 Asia Pacific, and in 2020 he was inducted to the Hall of Fame by the Legal 500 in both these areas of practice. He has been ranked in Band 1 by Chambers and Partners and is endorsed as an elite practitioner by Asia Law in the field of dispute resolution. He is also listed as highly regarded by IFLR 1000 in the fields of banking, energy, infrastructure, and project finance. Expert guides published by Euromoney lists Mr. De Silva as one of the world's leading practitioners in project finance. He is a visiting lecturer in commercial law at the Sri Lanka Law College and at the Master of Laws program of the University of Colombo. He was a member of the Law Commission of Sri Lanka. Mr. De Silva headed the committee of the Law Commission, which was entrusted with the task of drafting a new insolvency law for Sri Lanka. Our first co-arbitrator this afternoon, Mr. Chandaka Jayasundara, President's Counsel, has been in legal practice since 1991, specializing in commercial law with particular expertise in maritime law, multimodal, transport law, international trade law, company law, intellectual property law, and also arbitration. A significant part of his practice is before the Commercial High Court, the Admiralty Court, and the Superior Appellate Courts of Sri Lanka. He has also appeared in numerous local and international arbitrations, both as counsel and as arbitrator. Mr. Jayasundara previously served as part-time counsel in the chambers of Dr. Kanageeswaran, President's Counsel. He has also held several important public and advisory roles, including serving as advisor to the Ministry of Justice in relation to the Express Pearl maritime pollution incident, chairman of the Advisory Committee on Reforms in the Maritime Law Sector, and chairman of the Cabinet-appointed committee tasked with recommending reforms to Sri Lanka's maritime laws. He is also a former member of the Advisory Commission on Intellectual Property and a former lecturer in the law of contracts at Sri Lanka Law College. In addition to his legal practice, Mr. Jayasundara has contributed extensively to legal education. He has served as course director and lecturer for the certificate course on shipping law and practice conducted by the Ceylon Chamber of Commerce and the Institute for the Development of Commercial Law and Practice, and also as a visiting lecturer for the Diploma in Commercial Arbitration at the same institute. Our second co-arbitrator this afternoon, Dr. Asanga Gunawansa, President's Counsel, is a lawyer with over 30 years of experience in commercial law, investment law, project financing, construction law, environmental law, and alternative dispute resolution. He currently serves as lead counsel at the Colombo Law Alliance, a law chamber specializing in commercial law, construction law, and arbitration. In addition to his legal practice, he acts as an independent legal consultant, arbitrator, and adjudicator. Dr. Gunawansa has held several significant advisory roles, including serving as legal advisor to the Independent Redress Mechanism of the Green Climate Fund, an independent consultant to the Asian Development Bank on public-private partnership projects, honorary legal advisor to the Ministry of Justice of Sri Lanka, and legal consultant to the Sri Lanka Institute of Architects and the Chamber of Construction Industry of Sri Lanka. His teaching and research interests include construction law, arbitration, and other forms of alternative dispute resolution, infrastructure development, international environmental law, climate change, and also sustainable development. And now, to introduce the finalists this afternoon. Appearing as the claimant on behalf of Etoria Reclamation and Construction Company Private Limited is the team representing Singapore Management University. Appearing as the respondent on behalf of Alexandria Land Development Corporation is the team representing National University of Singapore. And to reconfirm, speakers, may I kindly request that you state your time allocations for submissions first and then your rebuttals, along with your team code and speaker role, so that the tribunal and my TO may keep a record of it.
To begin with, my name is Isabel Teo, and together with me is my co-counsel, Ms. Iman Nabila. We will both be speaking for 18 minutes, respectfully reserving 2 minutes for our rebuttals and our rebuttal respectively.
Good afternoon. I'm Varun Karthik, and together with me is my co-counsel, Mr. Jared Goh. I'll be addressing the procedural aspect, and Jared will be addressing the merits of the claim. I will take 13 minutes for my submissions and will need 3 minutes for rebuttal. Jared will take 20 minutes for his submissions and will reserve 4 minutes for rebuttals. And our team code is 34.
Thank you. To reiterate on the speaking order this afternoon, Respondent Speaker 1 will commence on procedure and then Claimant Speaker 1 on the same, followed by the Respondent rebuttal and Claimant surrebuttal. Then Claimant Speaker 1 will commence on merits and then Respondent Speaker 1 on the same, followed by their respective rebuttals and surrebuttals. And speakers, I would like to remind you that while you are speaking, I will be signaling the time remaining. So when there are 5 minutes left in your speech, I will ring the bell once. When there is 1 minute left, I will ring the bell once again. When your allotted time has expired, I will respectfully announce that your time is up. Please keep an ear out for the bell signals during your submissions. With that, I would like to thank and congratulate both the finalist teams for your undivided attention and wish you the best of luck for the final round. I will now be handing the controls over to the panel of arbitrators and starting the timer when Respondent 1 begins their speech.
So, are the council ready to commence? Clarifications. Okay, you may commence.
Good afternoon, Mr. Presiding Arbitrator and panel. My name is Varun Karthik, and together with my co-counsel, Mr. Jared Goh, we appear for the respondent, Alexandria Land Development Corporation. I'll be addressing the tribunal on the procedural issues for 16 minutes, and my co-counsel, Jared, will address the merits issues for 24 minutes. I will be reserving 30 minutes for my submissions and will reserve 3 minutes for rebuttals. Tribunal, the claimant has committed 2 fatal procedural errors. The first error they committed was in commencing arbitral proceedings prematurely by not complying with the mandatory pre-arbitral condition precedents outlined in the agreement between parties. The second procedural error the claimant committed was in commencing arbitration too late. The claimant's claim is out of time per the contractual time bar signed between parties. On these grounds, the respondent submits that the tribunal has jurisdiction to hear this dispute, but should find this dispute to be inadmissible. I'll now address both grounds in turn. On the first ground of non-compliance with the mandatory pre-arbitral conditions, if I can turn the tribunal's attention to page 11 of the proposition. And specifically the clause 11.1 of the agreement between parties. Clause 11 stipulates that 3 steps need to be undertaken before a dispute can proceed to arbitration. First, there must be a written request for amicable discussion. Second, if that fails, the dispute must be referred to the Minister of Land Development, who will attempt to facilitate an amicable settlement by negotiation. And third, if the dispute remains unresolved, the parties must proceed to mediation. Only if after all 3 steps have been undertaken can the matter proceed to arbitration. Flowing from this, I'll address the tribunal on why each of these 3 steps were not fulfilled by the claimant, and hence this matter is inadmissible for arbitration. First, on the requirement of a written request to the other party to reach an amicable resolution. We submit that this was not undertaken. The claimant's response is that there was an email sent on 15 July that fulfills this requirement. We disagree, and I'll explain why. If I can turn the tribunal's attention to Exhibit C8, which is on page 23.
Proceed.
Yeah. The claimant's position is that this constitutes a written request from them to the respondent for an attempt to reach amicable resolution. The first point I want to make is that, per the case of Lufthansa International, the court held that in determining if a condition precedent has been complied with, the test is a highly strict one, i.e. substantial compliance is not enough. The party needs to strictly comply with what is spelled out in the condition precedent. With that in mind, we think there are 2 deficiencies in Claimant Exhibit C8 that means that this cannot constitute a written notice under the first step. The first point is that what the email says is, quote, it asks the respondent to, quote, enlighten them on the reasons for such suspension and how we can proceed further. So what the claimant is asking for is a request for information, not an invitation for amicable resolution. So on that ground, this doesn't fulfill the requirements of step 1. But further, I'll point out that this email at no point references either clause 11.1 or references the dispute resolution clause. This again goes to show, we submit, that this email cannot fulfill the step 1 requirement.
Why do you say that this is an information request and not?
So if I can turn you to paragraph 4 of the email, it says, and I quote, please enlighten me on the reasons for such suspension and how we can proceed further. So in the event they were triggering the dispute resolution clause, they might have said something to the effect of, we have a dispute and we want to try and resolve this in an amicable manner pursuant to clause 11.1 or pursuant to step 1 of clause 11.1. They did not do so, and on the plain meaning, it just seems that they want a request for information, and they want more information about the suspension order. And that's why we think this doesn't fulfill step 1. Moving on to the second step then, the second step requires that the dispute be referred to the minister, who will then attempt to reach an amicable settlement between parties. It is uncontested that the claimant did not refer this dispute to the minister. But their submission is that they did not have to do so because this step is futile and therefore unenforceable. We have 2 responses to the argument on futility. Our first response is that futility is an incredibly high threshold. A clause can only be held to be futile if the dispute resolution mechanism becomes unworkable. We don't think they've adduced any arguments or any evidence to suggest that the dispute resolution clause became unworkable. Taken at their highest, all they can say is that the party who was supposed to preside this step of the process might have had some bias, but this does not make the process unworkable. And the second point I'll make on why the clause is not futile is that they quote the case DSQ versus DSR for the proposition that futility can be made out here. But we think that the case can be distinguished from the present one very simply. So in DSQ versus DSR, the dispute resolution clause was that there was a dispute adjudication board, a DAB, And in the event parties disagreed with the DAB's decision, they could then serve notice of dissatisfaction and then commence arbitral proceedings. There, the DAB had declined to decide the dispute in question. And on this basis, the tribunal and later the court held that because on the fact that the DAB had declined to decide the dispute resolution machinery had broken down, and therefore it was futile. But that is not the case here. Here, no attempt at all was made to even refer the matter to the minister. And so we think that step 2 rather is plainly enforceable, and their non-compliance means that the dispute is inadmissible for arbitration. Moving on to the third step then, which is that parties need to refer the matter to mediation. This again was not satisfied. And if I can draw the tribunal's attention to page 12 of the proposition, which is the contract between parties, I want to note that on page 12, it stipulates that if a mediator is not appointed within a reasonable period, or if mediation is not commenced, continued, or concluded for any reason, either party may refer the dispute directly to arbitration. So I do want to bring before the tribunal's attention that this line exists. But we don't think that this line means that the condition that matter needs to be referred to mediation rather becomes a directory condition precedent. We think that it remains a mandatory condition precedent. And that is because our submission is that if you take clause 11.1 as a whole, it is a mandatory step that parties need to refer the dispute to mediation. But if mediation cannot be commenced, then it can go to arbitration. And to find that it is a directory condition precedent will in essence render the first paragraph of on page 12 OTOs. And so therefore our submission is that step 3 also needs to be complied with because it is a mandatory condition precedent. So tribunal, it is clear from this analysis that none of the pre-arbitral steps were fulfilled by the claimant, and therefore this tribunal should find this dispute to be inadmissible on this ground. But on the second...
Is your objection that the tribunal does not have jurisdiction, or is your objection that the reference was bad?
Mr. Arbitrator, our objection is that the tribunal should find this to be inadmissible, but we think the tribunal does have jurisdiction to hear this issue. And so, if specifically the tribunal were to find that the preconditions were not fulfilled, we would ask that this tribunal grant a stay of proceedings and for parties to go through the steps in the dispute resolution clause before perhaps coming to the arbitration tribunal again if the dispute is
So in other words, what you're basically saying is that a stay should be granted at this point to enable the parties to comply with paragraphs 1, 2, and 3.
As far as the first grounds of our objections to admissibility are concerned, yes, a stay should be granted, yes. Moving on to our second grounds of objection on the time bar, if I can...
Sorry, before you proceed to the second argument of yours, now you drew our attention to Exhibit C8 at page 23.
Yes.
And you made a very selective reference there to paragraph 4. But what about the penultimate paragraph of that particular letter? And then also, what is your reading of C9, which is the response?
Yeah. So, Mr. Arbitrator, I think for the penultimate paragraph of C8, our view is that even if the claimant had said they might be compelled to pursue legal remedies, on what they should have done to trigger 11.1 is to say that is to send in a written request for amicable resolution. We think even if this perhaps puts the respondent on notice that there might be legal consequences, this does not fulfill the first step of 11.1, which is a request for amicable resolution. And so we don't think this fulfills the first step, or C8 on the whole fulfills the first step. Yeah. So, Mr. Arbitrator, my reading of that line in C9, which is we see no need to discuss anything further, concerns discussions about the request for information that was asked by the claimant in C8. So I don't see C9 as suggesting that that C8 was a request for discussion for amicable resolution. And again, I think that the test is a strict one. And so given especially, I think, the quantum of this contract, if the claimant did want to put the respondent on notice that they were triggering 11.1, I think it's fair that we expect them to at least mention the clause 11.1 and draw reference to the first step.
So the non-reference to the clause is fatal?
The claimant's view that the non-reference is, the respondent's view rather is yes, the non-reference is fatal. Or even if the non-reference
so
is...
in other words, what you're saying is, if you're giving a notice under clause 11.1, the clause must be mentioned. If not, it is not a notice under 11.1. Is that your position?
Mr. Arbitrator, perhaps I wouldn't pitch my case that high. I think it would be highly prudent for parties to mention the clause. But even if we don't think that the non-reference is fatal per se, construing Claimant Exhibit C8 on the whole, we can't say that this fulfills the requirements under Step 1. Yeah. So if I can turn to the second grounds of inadmissibility then, on the time bar, if I can turn the tribunal's attention to page 11 of the proposition, page 12 rather, of the proposition. So the agreement between parties clearly stipulates that arbitration proceedings shall be initiated within 3 months of the dispute arising. So the question then is, when did the dispute crystallize? Our submission is that the dispute crystallized at the latest on 20th of July. And for this, I'll turn the tribunal to page 23, which is Claimant Exhibit C8. The penultimate paragraph of the email, which says, "We may be compelled to pursue legal remedies," clearly suggests that the claimant disagreed with the suspension order placed by the respondent, i.e., a dispute had crystallized by this point. On this basis, we submit that the claimant should have commenced arbitral proceedings at the latest by the 15th of October, 2025, which is when the 3 months expires. Instead, the claimant only commenced proceedings on the 14th of January, 2026. And hence, on this basis, we submit that the claimant is out of time, and hence, this matter is inadmissible because of the contractual time bar. Unless the tribunal has any further questions, I wrap up my...
Aren't your two positions mutually contradictory? On the one hand, you are saying that the conditions to refer a matter to arbitration has not been fulfilled. On the other hand, you are saying that the arbitration is time barred. The reference is time barred. So are they not mutually contradictory?
Mr. Arbitrator, I don't see these two positions as mutually contradictory. I think the onus is on the claimant to both ensure that the pre-arbitral dispute resolution mechanism has been complied with, as well as ensure that if they want to bring an arbitration claim, to bring it within time. These are both requirements that should be placed on the claimant, and we don't see this as contradictory. And I think I would also point out that this is what both parties agreed to in the agreement itself, and so I don't think there's anything contradictory about expecting the claimant to adhere to what is in the agreement. Unless the tribunal has any further questions, I wrap up my submissions here.
Just one last question. So your reading of the last paragraph of 11.1, which refers to the fact that the arbitration proceeding shall be initiated within 3 months of the dispute arising. So what the commencement date of the dispute, according to you, is the date of the letter Exhibit 9, is it?
Claimant Exhibit C8.
C8,
So,
sorry, C8.
yeah, correct. So our view is that the dispute arose when both parties realized that they had contradicting positions on whether the suspension order was valid. And so by Claimant Exhibit C8, one of the parties is questioning the validity of the suspension order. So on that basis, at the very latest, 15 July, which is when this email was sent, there was a dispute between parties, and so that's when the 3 months should start.
Now, wouldn't the continuing suspension mean that there is a continuing dispute?
So, Mr. Arbitrator, if I can refer you to the words in the contract itself, it is that the 3 months commences when the dispute arises and not when the breach arises. So even if there is a continuing breach per se, which we dispute, at the point at which the claimant and the respondent had varying positions on the validity of the suspension order, we think a dispute had arisen.
question. If you look at clause 11.1, the fourth paragraph, why do you say that paragraphs 1, 2, 3 are a precondition or a condition precedent to paragraph 4 or the last paragraph?
So, Mr. Arbitrator, I think they are condition precedent, one, because of the use of the word shall. So shall is clearly suggests that this is something that parties need to do before the matter can be referred to arbitration. And I think even if you construe the clause 11 as a whole, it is clear that parties intended for these pre-arbitral steps to be complied with before the matter went to arbitration. And so on that basis, we think it's mandatory.
The words are shall be finally resolved. Words are shall be finally resolved. 11.1.
Which paragraph of 11.1?
11.1, last paragraph, page 12.
Page 12.
So doesn't the word shall relate to the method of resolution or method of final resolution?
Yeah, so I think this paragraph unequivocally states that in the event the dispute has not been settled by the other pre-arbitral steps, then the final forum will be arbitration. But I think the use of the word shall only goes to show that the final forum should be arbitration as opposed to litigation or as opposed to any other forum. But does not go to show that the other steps are directory as opposed to mandatory preconditions.
Okay. You can't hear that? Okay. Right.
We have to just put it on, no? Which we haven't done yet. We'll do that next time.
This is on, is it? Okay. No, we go to the other side. Yeah. Are you ready? You may proceed.
Good afternoon, Mr. President, members of this tribunal. As earlier introduced, my name is Isabel Teo, and together with my co-counsel, Ms. Iman Nabila, we represent the claimant, the Etoria Reclamation and Construction Company. I will speak for 18 minutes on the first prayer, respectfully reserving 2 minutes for my rebuttal. My co-counsel will then address this tribunal on the second and third prayers for 18 minutes, respectfully reserving 2 minutes for her rebuttal. Counsel for the respondent had earlier made 3 submissions on admissibility, that this tribunal should find the claim inadmissible, on compliance, and on the time bar. And I will respond to these in turn, specifically that this tribunal should find the claim admissible, that the claimant was excused from non-compliance, and that third, the claims are neither time-barred nor inadmissible. Turning then to my first submission, counsel for the respondent had earlier attempted to mount the alternative argument that the tribunal should find this claim inadmissible, and Mr. President had earlier queried counsel for the respondent on whether the tribunal had jurisdiction. Before I respond, on a point on procedural impropriety, the arguments raised in the respondent's submission are inconsistent with that of the first procedural order. And if I may refer this tribunal to page 48 of the record, this shows the first procedural order.
Carry on when you're ready.
Thank you. At paragraph 2, part A, it states whether the tribunal has jurisdiction to hear the dispute in light of clause 11 of the contract. The tribunal is bounded by the agreed issues, and this is per the 2011 Singapore Court of Appeal case of CRW Joint Operation and PT Perusahaan Gas, where the wording in relation to the pre-arbitral requirements clearly contests jurisdiction and not admissibility. This tribunal should not permit the respondent to mount this argument. We believe that failure to abide goes to jurisdiction. And now they are arguing that it goes towards admissibility. And this is precisely our point. However,
So is it your position that claims relating to admissibility or assertions relating to admissibility cannot be raised as preliminary issues? Is that your position?
that is not our position. Our position is that per paragraph 2A of the procedural order, the issue that is being arbitrated today is whether the tribunal has jurisdiction, not whether the claims are admissible or not. These are two separate dichotomies, and the dichotomy that is meant to be arbitrated today is that of the jurisdiction as opposed to admissibility dichotomy, and this was held in the 2025 Singapore High Court case of DRO and DRP.
Have they raised the issue of admissibility in their pleading?
Apologies, Mr. President, if I may clarify. Is Mr. President asking in relation to the respondent raising...
Respondent's objections, have they raised the position of admissibility in addition to jurisdiction?
They have, yes, indeed, they have raised this objection to admissibility.
Is it in issue?
This is an
Have
issue.
they raised it, placed it in issue as a point of dispute?
Apologies, Mr. President, if I may get Mr. President to repeat this question.
Now, if they have raised the issue of jurisdiction, you indicated that jurisdiction has already been placed in issue.
Yes.
I asked you the question whether the issue of admissibility has also been raised by the respondents. Your response was in the affirmative, that they have raised it. If they have raised it, have they raised an issue on it?
Yes.
Is it an issue in this arbitration?
This is not an issue in the arbitration because the point of this arbitration is to determine whether this tribunal has the jurisdiction to arbitrate and not whether the claims are inadmissible or admissible.
Understood.
Even if this tribunal was minded to entertain the argument, this should still fail because because counsel for the respondent has provided insufficient prejudice to determine that the claims should be inadmissible. I note that counsel for the respondent had relied on the case of IRC and Lufthansa. However, this case has been held to be not binding by the cases of by the 2026 Singapore High Court case of DSQ and DSR, as well as the 2026 Singapore High Court case of DRO and DRP. They held that IRC and Lufthansa is not binding because in that case, they never had to do with the issue of whether compliance with the pre-arbitral procedures are a matter of admissibility or jurisdiction. Rather, in that case, it was an uncontested premise that non-compliance went to jurisdiction, and as such, this case should not be applicable here. I note that counsel for the respondent had also relied on the word shall to argue that this claim should be inadmissible. However...
Can I pause you there for a moment?
Yes.
I believe in terms of the agreement,
Yes.
the law that is applicable
Yes.
is the law of Alexandria.
Yes.
How does that interact with the Singaporean cases that you cited?
Mr. President, the first issue that we are dealing with here is whether this tribunal has jurisdiction, and accordingly, whether non-compliance with the pre-arbitral procedures should go towards jurisdiction or admissibility. This is a legal question, and as per the arbitration agreement, at clause 10 of the record, and if I may refer this tribunal to page 11 of the record, it clearly states that this agreement shall be governed by and construed, apologies, if I may refer this tribunal to page 12 of the record, apologies for this mishap. At clause 11.2, it states that the seat of arbitration shall be in Singapore. Accordingly, procedural and legal issues such as whether non-compliance with the pre-arbitral procedures goes to that of admissibility or jurisdiction shall be governed by the law of the seat, which is that in Singapore. I note Mr. President's query on how it interacts with the Alexandrian law, and our position is that where it requires the interpretation of the arbitration agreement, this would be governed by the law of Alexandria. However, yes.
Thank you.
I note that counsel for the respondent had also argued that the claimant's initial email to the respondent on the 15th of July 2025, and this is at page 23 of the record, does not constitute a request. And their position is that the claimant did not refer to clause 11. However, this submission asks the tribunal to add a requirement that parties had not even included in the arbitration agreement in the first place. Clause 11.1 defines the written request precisely, that it must provide for a written request to ask the other party to participate in these dispute resolution mechanisms. However, it did not require that the written request include a reference to clause 11 or clause 5 of the contract. And the test for what a notice needs to convey is how a reasonable recipient would understand it in context, not whether it recites a clause number. And this was held in the 1997 England and Wales House of Lords case of Manai and Eaglesaw. In any case, the counsel for the respondent had also considered that not referencing the clause number is not fatal. And as such, even if counsel for the claimant, even if the claimant did not reference the clause number, this does not mean that the email was not a written request. Turning then to my second submission, even though the steps were not adhered to, this tribunal should find the claim admissible because the claimant was excused from compliance with the pre-arbitral procedures, where compliance would have been an act of futility. And this is for two reasons. First, due to the respondent's uncompromising and repeated refusal to engage with the claimant. And second, due to the conflict of interest which renders the pre-arbitral procedure unworkable. Counsel for the
I have two questions on that. Number one, why do you say that C8 is actually a request for amicable discussion of the dispute? Number two, you have obviously agreed to go before the minister in your dispute resolution clause. In those circumstances, can you set up the position of conflict of interest when you have agreed to that process, which is inherently leading to a conflict of interest?
Mr. President, if I may answer your questions in turn. On the first question on whether this email is a request for an amicable dispute resolution process, our position is that the claimant had sent this email on the 15th of July 2025, and in this email, it had initiated the dispute resolution process by asking for how the claimant can proceed in light of the suspension order. And notably, the written request is only required to be sent out 15 days after the suspension order. And indeed, the 15th of July 2025 is 15 days after the 30th of June 2025, which is when the suspension order was issued. On Mr. President's second question, that we had agreed to go with the minister, so how can we reference this conflict of interest? Our position is that at the point of contracting, the claimant had it was only foreseeable that the only governmental authority to have issued this suspension order is the one who is also in charge of approving this suspension order. And this is the Central Environmental Authority of Alexandria. It was not foreseeable that the president would be the one issuing the suspension order.
Sorry. Now, you agree that in terms of 11.1, the request for amicable resolution has to be made to the minister, correct?
Yes, Mr. Arbitrator.
So, this C8 is not referred to the minister. It's not addressed to the minister.
Yes, Mr. Arbitrator.
Is it?
It is not.
It's not. And then C9, that is the so-called refusal and your argument on futility, is by the chairperson of Alexandria Land Development Corporation.
Yes, Mr. Arbitrator.
Not the minister.
Yes, Mr. Arbitrator.
So there is no evidence that the claimant ever asked, requested from the minister.
Yes, Mr. Arbitrator.
So without requesting amicable settlement from the minister, how can you argue futility?
Our position is that where the respondent is a state-owned entity and it is under the directive of the minister, it is likely that the respondent's position is indicative that the minister would have had no interest in negotiating or mediating with the claimant in the first place. And beyond that, the pre-arbitral procedure was also unworkable, where the test is whether an informed observer would reasonably conclude that there is a real possibility of bias. And as such, the minister ought to be one that is neutral and disinterested in the outcome. But the minister is also the president of Alexandria, and it was the minister who is meant to facilitate the amicable settlement of the dispute. And the president is the one who issued the suspension order.
But that is what the parties agreed to. That was in existence at the time of agreement also.
Yes, Mr. Arbitrator. However, our position is that at the time of contracting, it was unforeseeable that the president would be the one who issues the suspension order. Rather, it was only foreseeable that the Central Protection Environmental Authority would be the one who issues the suspension order.
No. The
Yes.
suspension order is made by the respondent, by the corporation.
Yes.
Isn't it? Not the environmental authority. It's in the suspension order made by the authority.
Yes, Mr. Arbitrator, but if I may further color this picture, the suspension order was made under the directive of the president, and this can be found at page 17 of the record.
Yeah.
Which shows the directive of the suspension order, and at the third paragraph, it states, having been apprised by the Minister of Land Development, His Excellency the President. And in the seventh line, the Cabinet has decided that the reclamation activities should be suspended with immediate effect.
So your position is that the conflict of interest of the president arises because he himself was the one who initiated the suspension order.
Yes, Mr. President.
Proceed.
If I may make my next point, that the respondent had refused to engage with the claimant, the purpose of submission to the minister, as well as mediation, is to amicably resolve the dispute and presupposes the willing and engaged participation of both parties. Yet, the respondent's refusal to engage defeats the purpose of Clause 11. I note that counsel for the respondent had argued that these steps are mandatory, and we are not disputing the mandatory nature of these pre-arbitral procedures. Rather, this mandatory nature is not conclusive of whether it bars the tribunal's jurisdiction or renders it inadmissible. As such, the real issue that is before this tribunal today is whether compliance would have been an act of futility, and thereafter whether the claimant is relieved from compliance. I note that counsel for... Yes.
So, who decides whether it is act of futility or not?
This would be the tribunal. And
But you have decided already that it's, the claimant has decided already that it's an act of futility when the reply came from the chairman of the corporation.
yes,
So-
Mr. Arbitrator. However, we are now asking this tribunal to formally declare that that compliance with these pre-arbitral steps would have been an act of futility.
Counsel, can I also seek a clarification from you? Could I draw your attention to page 22 of the brief, which is the affidavit of Michael Hamilton?
Yes, Mr. Arbitrator.
Yeah. Now, if you look at paragraph 12 of that, it says our company decided to initiate this arbitration only after exhausting all attempts to contact and negotiate with the respondent regarding the recommencement or discontinuation and so on.
Yes, Mr. Arbitrator.
Right. But the only document that you are relying on to say that you have attempted to amicably resolve this is what we find in C8 and C9, is it?
No, Mr. Arbitrator, we are not just relying on Exhibits C8 and C9 to substantiate. Members of this tribunal, I note that my time has elapsed. If I may answer Mr. Arbitrator's question before
Please
concluding. Yes, thank you. Our position is that the claimant had persisted in reaching out from the months of July to September 2025, and this can be found at page 5 of the record at paragraph 28. This shows the request for arbitration. However, notably, the respondent has not disputed this fact that from the months of July to September, the claimant did indeed reach out, but to no avail, where the respondent has consistently stonewalled every single one of these every one of these emails. Our argument, thus, is that where the respondent has consistently stonewalled the claimant would not be able to have done anything, and in any case, the respondent would not have come to the table, and thus there was nothing left for the claimant to do but to commence the present proceedings. With that, unless I may be of further assistance.
What is your response to the second argument relating to the time bar? Be brief, please, and direct.
Yes, Mr. President. Apologies. I note my time, and if I may provide a brief snapshot of my argument, our position is that arbitration was commenced within 3 months of the dispute arising. A dispute is defined as a claim as well as a non-admission of the claim, where failure of a party to respond is equivocal, and where the respondent's last email was on the 20th of July 2025, and the respondent did not reply to any one of the claimant's further emails. This means that the respondent has consistently stonewalled the claimant. However, this silence is equivocal because failure by a party to respond has been held to be equivocal, and especially where detailed investigation is required, as in the present case, 3 months constitutes a reasonable period of time before silence crystallizes into a non-admission of the claim. And this can be further found at paragraph 20 of my written submissions for more detail. As such, 3 months following the last email of the respondent on the 20th of July 2025 will be that of 20th October 2025. And as such, our position is that the dispute only arose on the 20th of October 2025. This would mean that this is still within the 3-month period prior to the commencement of arbitration, and thus arbitration was timely.
So in other words, you are saying that the 3 months should be counted from the 25th of October?
The 20th of October 2025, Mr. President.
20th of October?
Yes, Mr. President.
Yeah.
But isn't the dispute the suspension?
No, Mr. President. If I may refer this tribunal to page 18 of the record. This shows the suspension order, and notably, at the bottom of the page, the claimant has signed this suspension order, demonstrating that the claimant acknowledges the suspension order. As such, the suspension order is not the dispute here. Rather, the dispute is about the respondent's refusal to provide any further information to the claimant. in relation to how both parties can proceed further. With that, apologies, Mr. President. With that, I conclude my submissions. Thank you.
We now go to the second.
Or you want to, he has to rebut, no? He has to rebut.
Yeah, okay. Okay. Okay.
So, Tribunal, I have three main rebuttals I want to address. Firstly, I want to address the claimant's notion that it was procedurally improper for us to make arguments about admissibility as opposed to jurisdiction. Secondly, I want to address the arguments on why the mandatory preconditions are unenforceable. And lastly, I want to address on why the time bar, on the time bar issue. Firstly, on the arguments that it was procedurally improper for us to raise arguments about admissibility as opposed to jurisdiction. If you can turn the tribunal to page 48, which is procedural order number 1. My learned friend drew the tribunal's attention to the fact that the procedural order talks about jurisdiction. But if you look right below that, at 2A subsection A and subsection B, it talks about the pre-arbitral dispute resolution requirements as well as the time bar. So I think it is clear that the procedural order allows the parties to make the arguments we are making. And so if our position on the jurisdiction is just that the tribunal has the jurisdiction to hear this matter, but this dispute is inadmissible for the reasons we submitted. So we don't see this as procedurally improper for us to make arguments about admissibility. I think the claimant's counsel is splitting hairs by arguing that we can't make these arguments. Moving on then about the mandatory preconditions. So if I can take you to each of the preconditions. As far as the first precondition is concerned, the written request, the argument is that the email on claimant exhibit C8, which is at page 23, fulfills this requirement because of the context, they say. And when asked about what the context is, they say the context is because this was made within 15 days, and so therefore they should have known. I don't think this is particularly persuasive, and I think I have made our arguments on why this exhibit does not fulfill those requirements, and I'll just add that I don't think just because this was within 15 days, this fulfills the requirement of step A. As for steps B and C, they have two arguments. The first argument is that it was futile. I've already made known our position on this. Our position is that futility only happens when the dispute resolution mechanism breaks down. But just because there was bias doesn't mean the dispute resolution mechanism broke down. But the argument they also make on futility is that there was nothing left for the claimant to do, therefore they commence arbitration. Our position is that there were things for the claimant to do. They should have fulfilled the steps here. So for instance, they should have submitted a written notice for a discussion of amicable resolution. They should have submitted to the minister in charge and asked him to facilitate an amicable settlement. They should have went through the steps and they should have commenced mediation. Their failure to do so means that this matter is inadmissible. I understand I'm out of time. If I can just have one additional minute to deal with one last argument, which is that on the time bar issue, their argument is, they essentially have two arguments, I think. The first argument they make is that because the claimant had signed the suspension order, therefore he acknowledged it and therefore there was no dispute at that point. I don't think that is fair. Just because the claimant acknowledged the suspension order does not mean that they agree with the suspension order. And in fact, I'll tell you that their argument, as it concerns the written request, was that because the written request was within 15 days of the dispute arising, therefore this fulfills step A. But if you do the math based on that, in their words, the dispute arising per clause 11 should be on the 1st of July, and the 3 months from the 1st of July is actually the 1st of October. And so their own internal position, I think, is contradictory. On the first issue, they say the dispute arose on the 1st of July, but when it comes to the time bar, they say actually the dispute arose much later. And so those are my submissions, unless the tribunal has any questions.
So in the context of them acknowledging the suspension order, why do you say, or what material do you have to say that they actually disputed the suspension order?
We say that they disputed the suspension order because of claimant exhibit C8, the email on the 15th of July, informing them that they may be compelled to pursue legal remedies if the suspension is not lifted without undue delay.
So couldn't it be argued that the lifting of the suspension or the non-lifting of the suspension is what they're agitating against, not the imposition of the suspension per se?
I think that is a reasonable position, but I think even if we say that the dispute is about the non-lifting of the suspension order, it was clear that the dispute about the non-lifting of the suspension order arose on the 15th of July. So even by that math, they would be contractually time barred from commencing arbitral proceedings.
Double, one declaration is suspension, second one is lifting. First relief is declaration of suspension, second one is lifting. So both will,
Do they have an ability to reply? You have an ability to reply. They reply now, is it? Yeah. Okay. Please proceed.
Members of this tribunal, I note that counsel for the respondent had made 4 points in rebuttal, of which the last point on the time bar and where the dispute had arose, we have made explicitly clear in our submissions, and we will not be addressing that. On the first point of the procedural impropriety, at page 48 of the record, the only time where inadmissibility is raised is at part 2AB of the procedural order, which relates to the time bar. And this is because time bars are generally a matter of admissibility, and this was held in the 2020 Singapore Court of Appeal case of BTN and BTP. As such, the overarching issue is still that of whether this tribunal has jurisdiction, and thus this means that the respondent's argument is still procedurally improper. On counsel for the respondent's second point on the mandatory nature of the preconditions, Clause 11 specifically states that any dispute, controversy, or claim which remains unresolved for more than 15 days after one party has made a written request to the other to participate in discussions to pursue the possibility of reaching an amicable resolution. It does not require the specification of any clauses. And on counsel for the respondent's third argument on futility, where there was nothing left for the claimant to do, our position is that up to today, the suspension order is still in force, more than a year since it was first enacted. And this is indicative that any response from the respondent was merely a fig leaf, where they had already made up their mind at the point of 20th July 2025 not to engage with the claimant. As such, members of this tribunal, I note that my time has elapsed unless I may be of further assistance.
just one. What are you seeking on the merits in this arbitration?
Apologies.
The relief you are seeking from the arbitrator, the tribunal?
We are seeking that this tribunal declare that the contract is terminated and thereafter that damages follow. And
That there is a breach of contract.
yes.
That is on the suspension.
No, Mr. Arbitrator.
Look at page 5, your request, paragraph 30. Declaration that the unilateral and immediate suspension of the project by the respondent constitutes a breach of contract.
Yes,
Correct?
Mr. Arbitrator.
So that happened on 15th, even by your argument is 1st of July, acknowledgement is 1st of July, right? By the claimant?
Yes.
Right. Then the second claim that you are making is a declaration for the failure and refusal to remove the suspension within 90 days.
Yes.
Okay, so that takes you to when?
This would be...
90 days from the 1st of July. It's not actually 1st of July.
This would be 90 days from the 30th of June.
Which takes you to?
This would be...
3 months.
Yes.
July, August, September.
However, if I may further clarify our position, this is in relation to parts A and B. This is in regard to clause 7.1 of the contract, which is when the claimant is entitled to terminate the contract. This would be distinct from our argument that a dispute arose on the 20th of October 2025 because a dispute is defined as a claim and a non-admission of the claim. As such, a dispute only crystallized due to the respondent's non-admission on the 20th of October 2025. With that, I conclude my rebuttals. Thank you.
Yeah, I would like to ask you one more question. Yes. It arises from the concession that was made by the respondents that all they're seeking at this stage is for the arbitration proceedings to be stayed to enable the parties to comply with the first part of clause 11.1. What is your response to that? And I would like it in brief. So they are not asking for the dismissal of the claim. They are asking for it to be stayed for you to comply with that.
Mr. President, we are open to staying the proceedings. However, our position is that even if this tribunal chooses to stay the proceedings, ultimately, the respondent's refusal to engage has clearly shown that they are unwilling to engage in any of the pre-arbitral steps with the claimant, and as such, this would ultimately still be a futile process. Thank you, members of this tribunal.
Now we go to the second part of it. Are you ready?
Yes, Mr. President.
Okay. You make a moment.
Good afternoon, Mr. President, members of the tribunal. As earlier introduced by my co-counsel, my name is Iman Nabila. I will be speaking for 18 minutes on the second prayer that the claimant is entitled to terminate the contract, as well as the third prayer that the claimant is subsequently entitled to damages and compensation. Members of the tribunal, the present dispute arises out of the change in the Alexandrian government and the current administration's determination to honor its campaign promises at the expense of the claimant. On the 30th of June 2025, 3 years and 65% of works into a contract worth $950 million, the respondent unilaterally suspended the project and blamed the claimant. Yet, every ground that it relied upon was one that had been contractually assumed by the respondent. The sole question then is this: was the suspension order issued at the fault of the claimant? I will thus make two submissions. First, that the claimant is entitled to terminate the contract pursuant to clause 7.1, as the suspension order was issued for no fault of the claimant. Second, that the claimant is subsequently entitled to damages as provided for in clause 7.2. Turning then to my first submission, that the claimant is entitled to terminate the contract per clause 7.1. Members of the tribunal, if I may first refer you to page 10 of the record.
Proceed, please.
At the bottom of the page is clause 7.1, which sets out the 3 requirements that must be fulfilled before the claimant has a right to terminate the contract. The first requirement, in the event that the performance of the reclamation and development works by the investor, the claimant, is suspended, hindered, or delayed by the employer, the respondent, or by any governmental authority of the Republic of Alexandria. The second requirement, for no fault and or breach on the part of the respondent. And then the third requirement, for a continuous period exceeding 90 days. When these three requirements have been fulfilled, then, as per page 11 of the record, the claimant has a right to terminate the contract. Of these three requirements, the first and the third are not in contention. The contention then is the second requirement. Was the suspension order issued at the fault of the claimant? To address this, we should then turn to the grounds of the suspension order as issued by the respondent. If I may thus turn the tribunal to page 18 of the record. This would be the suspension order that was issued. In the middle of the page, under background to issuance of suspension order, if the tribunal is with me, there are three grounds listed here. First, the faulty environmental impact assessments, or EIAs. Second, the improper regulatory approvals. And third, that the project is an unsolicited proposal. Members of the tribunal, of these three grounds, only two can possibly attribute any fault to the claimant. That would be the ground of the faulty EIA or the ground of the improper regulatory approvals. I will thus deal with each of these grounds in turn and submit that neither of these can attribute fault to the claimant. Preliminarily, it should be noted that these grounds are merely based on preliminary allegations and stakeholder complaints. However, these grounds have yet to be proven nor investigated, where the respondent has still not conducted their intended independent investigation to date. On the first ground of the faulty EIA, where there is no proof on the record that the EIA was indeed faulty, our position is that the EIA met the statutory standard as reflected in the Alexandrian Environmental Act 2015. The act in question can be found at page 40 of the record.
Go ahead.
For the tribunal's reference, this would be section 49 at the top of the page, which sets out the requirements of the contents that should be included in an EIA. Specifically, at subsection 3, a description of the receiving environment, subsection 4, a description of the potential environmental impact, subsection 5, a description of the mitigation measures, and subsection 6, an indication of the predictive methods used. Members of the tribunal, based on these statutory requirements, it is not a requirement that an EIA be retrospectively accurate. Rather, it is emphasized that an EIA is inherently predictive. Accordingly, the respondent cannot seek to rely on the actual outcomes reported by the Great Ocean think tank to say that the EIA was deficient. The respondent cannot seek to rely on the divergence between the predicted outcomes and the actual outcomes to say that there was a breach of the statutory standards.
But in those circumstances, cannot one argue that there is an obligation on you to have picked this up when you were doing the study and you have failed to do that, and that constitutes a breach?
Certainly, Mr. President. However, if I may, this study at that point in time was, to the best of the claimant's knowledge, not deficient. This means that the alleged outcomes, as reported by the respondent, was not within the predicted outcomes that our expert report indicated. And further, even if the EIA had truly been deficient at that point in time, then as the approving authority, or as the authority who had granted the approval of this EIA, the respondent cannot now seek to say that that EIA was deficient. Presumably, had there really been deficiencies within the EIA at the time of submission, then these deficiencies would have been raised by the respondent and approval would have been withheld. Yet, approval had simply been granted and the claimant had no knowledge of any such deficiencies. Further, even if the respondent now seeks to raise the argument that there is new information as to the actual outcomes that are reported, it is crucial to note that at no point in time was this supposed report by the Marine Authority of Alexandria actually made known to the claimant. At no point in time was this report produced, nor these concerns raised to the claimant. And so the claimant cannot possibly bear fault for concerns that the respondent had withheld for over a year. This is especially so when the claimant had reached out to the respondent multiple times to inquire as to the reasons for the suspension order, but to no avail, where the respondent refused to grant us access to the information that would have allowed us to make the necessary amendments or to actually deal with this divergence or the faulty EIA as alleged by them, then they cannot now seek to say that this is our fault. As an additional point, it should be noted that not only have they not produced this expert report, they have also not established causation, in that they only alleged that this environmental impacts actually occurred as a result of Veronia project, but they did not show that this link is actually made clear. Rather, it should be taken into consideration that these impacts could also be a result of many other factors, such as environmental concerns that simply could not have been predicted and separate from the Veronia project itself. On the second ground of the improper regulatory approvals, as stated in the suspension order, our position is that this was not the claimant's contractual responsibility, and fault cannot be attributed to the claimant on this ground. If I may refer the tribunal to page 10 of the record.
Go ahead, please.
Clause 5.2 expressly provides that the respondent accepts all risks associated with delay or denials of the regulatory approvals. Hence, while the claimant was indeed responsible for submitting an EIA to the competent authority and for ensuring that, to the best of our knowledge, this EIA was not deficient, the obtaining of the regulatory approvals and the adequacy of these regulatory processes was subject to the respondent. This was the respondent's obligation and responsibility, and so the respondent cannot now claim that there was impropriety in the processes and that this is a fault that the claimant must bear.
Do you accept the position that the obligation to give a proper EIA was on the claimant?
Yes, Mr. President. We do accept that the obligation to give a proper EIA was the claimant's responsibility, and to the best of our knowledge, we had certainly submitted an EIA that was not deficient. Having dealt with each ground in the suspension order, our position is that the issuance of the suspension order cannot have been for any fault of the claimant, and so accordingly, the claimant is entitled to terminate the contract pursuant to clause 7.1. Turning then to my second submission, following the termination of clause 7.1, the claimant is then entitled to damages as provided for in clause 7.2. Specifically, the claimant is claiming for a sum of 850 million USD. This value is based on the breakdown of damages contractually agreed upon by both parties in clause 7.2. If I may refer the tribunal to page 11 of the record, I hope that the tribunal can bear with me as I bring you through the mathematical calculations for the damages. First, clause 7.2a provides for the return of the total sum invested in the project by the claimant to date, which would be approximately $617.5 million. Plus a percentage uplift of one of two options, either 25% of the sum yet to be invested, which would be approximately 83.1 million, or 15% of the sum that has been invested, which would be approximately $92.6 million. Given that $92.6 million is the higher figure, then the total sum claimable under clause 7.2a amounts to 710.1 million, which is the sum of 617.5 and 92.6. where the claimant is claiming for a total of $850 million, the remaining $140 million can be attributed to Clause 7.2b, which provides for all costs reasonably incurred by the claimant in anticipation of continued performance and the subsequent winding down of the site operations. Our position is that where the claimant had already invested more than $600 million into the project for 3 years worth of reclamation works, and taking into account the absolute scale and enormity of the project spanning across 300 hectares worth of land, then it is reasonable that the amount required for the labor of winding down the site operations and the dismantling of these heavy machineries related to the reclamation of land does amount to $140 million. Next, our position is also that the claimant has discharged.
So your position is $140 million is winding down costs?
Yes, Mr. President.
Okay. Go ahead.
The claimant has also discharged any duty to mitigate. Crucially, this duty is merely one that a reasonable and prudent man would take in the ordinary course of his business. In the present case, the claimant has sufficiently discharged any duty to mitigate through the attempts to reach out to the respondent multiple times over the course of 3 months. Following the issuance of the suspension order on the 30th of June, the claimant had reached out to the respondent to inquire further reasons as to the suspension order, as well as to seek clarity as to the further steps that could be taken by both parties. Yet, instead of providing a sufficient response, the respondent chose to stonewall the claimant and further bar any future communications. And this is evident also from the fact that despite the claimant's attempts to reach out to them for the next 3 months up to the month of September, all their attempts were in vain. Accordingly, this suffices the duty to mitigate, where the claimant had done everything that was reasonably possible. As a final point, the claimant can also claim for costs as per Clause 7.2c of the contract and Article 38, subsection 5 of the ICC Rules of Arbitration. At page 11 of the record, Clause 7.2c provides for interest on all such sums at a rate of 10% per annum. Where both parties were of equal bargaining power and were experts in their respective areas who entered this contract freely and at high value, it is clear that the parties had intended to allocate the risk as per the contractual agreement. And so the claimant is entitled to claim costs as per Clause 7.2c. Further, the tribunal should also account for the parties' conduct both during and before the arbitration proceedings began. As per Article 38, subsection 5 of the ICC Rules of Arbitration, in deciding costs, the arbitral tribunal may consider such circumstances as it considers relevant, which includes the extent to which each party has conducted the arbitration in an expeditious and cost-effective manner. And this broad language allows for the conduct of all parties to be taken into consideration, both during and before the proceedings, regardless of whether such conduct caused a delay or otherwise increased the cost of arbitration. Our submission is that the respondent had acted in bad faith by using the alleged invalidity of an EIA that its own government had approved as a pretext to halt the project that the claimant had performed for 3 years to a 65% completion rate. The respondent's pre-arbitral conduct in manufacturing this dispute by relying on its own breach justifies shifting the entirety of the cost to them. This thus concludes my final submission and my submissions as a whole. Thank you.
Now, one question arising from your opening statement that you are addressing us on the second and third reliefs that you have claimed. Is it your position that you're abandoning the first relief you have claimed?
May I clarify with the President
Yes.
as to what the first relief?
In your reliefs, that is at page 5. paragraph 30 of your statement of claim, you said that you are proceeding to make submissions to us on reliefs B and C, but there is a relief A. Are you abandoning your relief A?
Mr. President, if I may clarify our position, our primary submission is that the claimant is entitled to terminate the contract pursuant to clause 7.1. That would be declaration B. Our alternative argument would then be that the respondent's act of issuing the suspension order does constitute a breach of contract, and that argument itself can be found within our written memorials. However, we have chosen to focus on the second relief sought in our oral submissions today. Thank you.
Does it go on the second one? Time by is out.
Any
Good afternoon, Mr. President, members of the tribunal. My name is Jared Goh, and I appear on behalf of the respondent, Alexandria Land Development Corporation. My arguments will be canvassed to address issues 2 and 3 of the merits of the present arbitration, including the right to terminate or lack thereof, and the quantification of damages respectively. I will take 20 minutes for my submissions and reserve 4 minutes for Sir rebuttals. For my first submission on breach and the claimant's right to terminate, I have 2 points. First, the claimant cannot terminate the contract because the pre-contractual termination requirements under clause 7.1 have not been satisfied. And next, the respondent's suspension in the alternative does not constitute a breach of contract. For my second submission on damages, I have another 2 points. First, it is submitted that clause 7.2 is unenforceable because it amounts to a penalty clause. And second, even if common law damages were open, it is submitted that the expectation losses claimed are too remote and speculative. I would like to move on to my first submission that the claimant had failed to satisfy the contractual pre-requirements to termination under clause 7.1. First, I would like to turn this tribunal's attention to page 10 of the proposition. Page 10, at the bottom of page 10, we see clause 7.1. And on a plain reading, the claimant's right to termination pursuant to clause 7.1 depends on satisfying 2 cumulative preconditions. The first is that there must be no fault and or breach on the part of the claimant, and the second is that the termination notice must be provided to the respondent by the claimant in writing. It is submitted that neither of these 2 have been satisfied. Allow me to first turn this tribunal to page 39 of the proposition. Page 39 of the proposition is the Environmental Act. I would like to highlight the bottom of page 39, which indicates section 49, and the contents required in an environmental impact assessment or an EIA. Here, I would like the tribunal to turn to the next page on page 40, and more importantly, I would like to highlight subsections 5, subsection 6, subsections 7, subsections 8, and subsections 9 of section 49. In brief, I would like to read out to the tribunal that the requirements of an EIA need, for subsection 5 onwards, a description of mitigation measures, an explicit indication of predictive methods, an identification of gaps in knowledge, an outline for monitoring and management programs, and lastly, a non-technical summary, including a visual presentation. It is important that section 49 indicates in the header on page 39 that this information to be included is as a minimum, shall be included as a minimum. These are mandatory requirements that need to be included in an EIA. Yet, I would like to turn this tribunal to Respondent Exhibit R5 on page 42 of the proposition. Here, we see an aquatic environmental impact assessment or an excerpt of it. In this, I would like to point to the last sentence of the second paragraph that states, represented by the claimant in their EIA, that the ordinary marine ecosystem, such as marine animals, flora, and fauna, alongside minute changes to the nature of the ocean in coastal areas. Here, if the tribunal applies their mind to Respondent Exhibit R5, it is plainly clear that the Section 49 requirements, namely subsections 5, 6, 7, 8, and 9, were not included in any case. Therefore, it is submitted before this tribunal that the claimant is at fault for the deficient EIA simply because they failed to adhere to the requirements in Section 49.
Okay, if your position is that they fail to adhere to those, why did the respondent wait for 3.5 years to act on that? And even at the time of suspension, the respondent does not seem to have been aware of that. You are still conducting an investigation.
Mr. President.
How do you say that there was a breach?
I have a related question. Perhaps you can answer both then. If you look at page 43, that is Exhibit R6 of the respondent, which is the EIA approval granted on 30th of March 2022. Now, there are no reservations held in granting the EIA approval.
Yes.
So on the one hand, as the investor and developer, the claimant has done an EIA study and submitted it to the relevant competent authority for approval, and the competent authority grants it at that point of time, and it's only pursuant to a change of government that there have been a different position taken, right?
Yes.
So can you hold the claimant responsible for that?
Mr. President and Mr. Arbitrator, I would like to take your questions in turn. First, I would like to canvass that as a preliminary point, the respondent is not arguing that the respondent is not entirely at fault. What we are arguing is that the right to terminate on the claimant's end under Clause 7.1 depends on the claimant not having any fault. Here, even if the respondent was at fault for accepting the wrong EIA or the deficient EIA, it is submitted that this fault of the deficient EIA was attributed to the claimant. And in any case, if the claimant was at fault for any part of the deficient EIA, as will be submitted subsequently, it is submitted that Clause 7.1 contractual preconditions are not satisfied, and therefore the right to terminate on the claimant's end has not accrued.
In that context, I have a further question to ask you. In terms of the contract, the obligation of acquiring the approvals is that of the respondent.
Yes.
Although it appears that the EIA has to be provided by the claimant. Now, also it is stated in one of the clauses, I think in Clause 7 or something like that, that they will not be responsible, the claimant is not responsible for any fault relating to approvals. How do you see those clauses? Or what is your argument in the context of those clauses?
Also related questions so that you can deal with both. I would like to draw your attention to Exhibit C8 and C9, which the claimant has relied on.
Yes.
Now, C8 is the letter, according to the claimant, that they have sent in compliance with Clause 7.1 of the agreement.
Yes.
Where in, I think, paragraph 4, they are saying, please enlighten me on the reasons for such suspension and how we can proceed further.
Yes.
Right? So basically, an invitation is being made to explain as to how the matter could be taken forward or to resolve. Then, if you look at C9, which is the response from the Alexandria Land Development Corporation, it basically says in the third paragraph, I see no need to discuss anything further, right?
Yes.
With you until conclusion of an independent investigation.
Yes.
Now, isn't the question that the investigation itself has not been concluded within a reasonable period of time, and that is what triggered the claimant's right to terminate in terms of the contract?
All right. Mr. President and Mr. Arbitrator, I would like to again take your questions in turn. For Mr. President's question on the assumption of risk on the part of the respondent, the simple answer is that reading Clause 5.2 in its plain reading says that the employer acknowledges regulatory approval processes are subject to the discretion of the competent authorities and, most importantly, accepts all risks associated with delays and denials of such approval. Here, the key point is that the risks are associated with delays and denials of the approval. But it does not relate...
Is that a risk which is delay or denial? There was
Precisely,
no
Mr.
delay and there was no denial. It was granted within time, which enabled them to proceed. And that is confirmed by C2, isn't it? So in that context, can you take refuge under that clause and say that there is a delay or denial? This is a subsequent event.
Mr. President, allow me to clarify my position. Clause 5.2 allocates the responsibility of assuming such responsibility for the delay and denial to the respondent. However, the respondent's position is that this delay or denial does not absolve the claimant from the fault of the EIA. It relates to regulatory delay, regulatory approval, and regulatory denials. It does not relate to the fault of the claimant for a deficient EIA. Now, moving on to Mr. Arbitrator's question on whether or not this Claimant Exhibit C8 as well as Claimant Exhibit C9 with regards to the environmental impact assessment and the approval could have been deficient, I would like to highlight, first of all, the differences between the EIA submitted by the claimant and the contemporaneous record, or rather, what actually happened. Now, pursuant to Clause 3.2a of the contract, if I may turn this tribunal's attention to page 9. If the tribunal is with me on this, Clause 3.2a states that the investor, or rather the claimant in this case, represents that to the best of its knowledge, there are no deficiencies in the environmental impact assessment study. Yet, on the contemporaneous record, there are clear discrepancies. For one example, I may turn to Respondent Exhibit R2 of the Respondent Exhibit R2 of the proposition. This is on page 36. Now, if the tribunal is with me on this, I would like to highlight the second paragraph of Respondent Exhibit R2, which states that there are 1.5 meters of coastline erosion, 2 meters of certain areas of the tide line increasing, severe coral discoloration, and 75% reduction in local fisher catch. Yet in Respondent Exhibit R5, which was the EIA submitted by the claimant, they said, and I quote in the last sentence, minute changes to the environment. Clearly, there is a disproportionate impact on the environment compared to that represented by the claimant. I would like to impress on this tribunal that the claimant is
So in that context, from a subsequent event that has been observed, could you conclude that the EIA itself is faulty? Isn't there more responsibility on the respondent to show that that was deliberately omitted or negligently omitted?
Yes, Mr. President. Allow me to take this question in 2 points. The first point is that, as elaborated earlier, the claimant has failed to satisfy the Section 49 requirements of the Environmental Act. These are, at minimum, things that need to be included in a valid EIA. Statutorily, the claimant has not complied with the same. The second argument is that, in any case, the claimant is a party with specialist knowledge. The claimant has represented itself to be a large-scale land reclamation company. And in fact, I would like to turn this tribunal's attention to Claimant Exhibit C7, page 21 of the Moot proposition. Page 21, if the tribunal is with me on this, is a statement by Michael Hamilton, is the CEO of the claimant. In paragraph 8, I would like to highlight that Michael Hamilton, the CEO, stated, and I quote, "We took a lot of inspiration from the underwater hotel we constructed in Itoria." Clearly, the claimant has done projects of a similar scale, projects with regards to the environment, and has impacts on the environment. Therefore, given the claimant's position as one of possessing a special skill and expertise, the representation of the claimant in Clause 3.2a that there will be no deficiencies in the EIA, contrasted with the current record, where obviously there are major disproportionate environmental impacts, highlights that there could not be a reasonable inference that there are no deficiencies, and therefore fault is allocated to
So if there were such significant deficiencies, how come the environmental approval was granted on that EIA? Was it not picked up at that time? And if so, who is responsible for that?
Mr. President, to address that issue, again, I have 2 points. The first is that the approval was not that the EIA was sufficient. The approval was that the conditions precedent were satisfied, or rather, that the EIA was submitted. we recognized the EIA. It was a procedural approval. Second is that this EIA could not have been known to the respondent at the time of approval. We relied on the expertise of the claimant to approve the EIA when they had represented a state of special knowledge and expertise, and this cannot be attributed to the respondent for not knowing this at the material time. However, if I will bring this tribunal to the point where we are today in the arbitration, it is clear that the discrepancies between, and I quote from the claimant's EIA, the minute changes and the disproportionate changes in the environment as found on a contemporaneous record clearly indicate there was a deficiency, and because of this deficiency, the claimant is at fault, and because of the fault, the precondition to terminate under section 7.1, clause 7.1 is not satisfied.
Sorry, can you look at page 9 of the brief, 5.1.1, 4, Roman 4?
Yes, Mr. Arbitrator.
So the precondition is that the environmental authority has issued an environmental protection approval, okay, not submitting,
Yes.
issued, and the certification has to confirm that the required environmental clearance and approval have been granted. Okay?
Yes.
And that granting happens when the claimant satisfies section 49, correct?
Yes, Mr. Arbitrator.
Right? Okay. So they have done their job. They have tendered a certificate from the Environmental Authority which says that they have satisfied the criteria in the Act. Now, is it then fair to then foist it upon them now, saying that because you also have to understand these are all the same government organizations,
Yes.
right? And is it now fair to accuse them of a breach when your own environmental organization has given approval that it satisfied the Environmental Act requirements?
Yes.
Now, I have a question connected to that itself. Now, even assuming that your obligation was only the precondition was only the submission of an EIA,
Yes.
when you certify that they have submitted an EIA, are you not certifying that they have submitted an EIA which complies with the relevant statutory requirement? Can you now come back and say, no, they have submitted some piece of paper, but that does not satisfy the statutory requirements?
And
isn't that something
yeah.
that you are catching after the fact?
And how would you deal with the presumption that all official acts are done correctly?
Sorry, Mr. Arbitrator, could you repeat?
There is a presumption of law that all official acts are
Yes.
done correctly. There's a
Yes.
rebuttable,
Yes.
but it is. So where is the evidence to show that that official act was not done properly?
Yes. All right, to address Mr. President and Mr. Arbitrator's questions, I'd like to quickly canvass that the respondent's position, again, is not that the respondent is absolved from any fault. Sure, we could have approved the EIA or we could have had more stringent processes. However, I would like to impress before this tribunal that on a plain reading of clause 7.1 of the contract, the right to terminate the contract on the claimant's end is pursuant to no fault and or breach on the claimant's
So,
end.
but you are putting the fault on them
Yes.
for something they are not obliged to. Because the certification has been granted, that's all they were supposed to give. A certified or a certification from the Environmental Authority that they have, that the wording is, that the approval to commence and complete the project. So how can you now foist that
Yes.
obligation of the authority on the claimant
After the fact.
after the
Long
fact?
after the fact.
Yes. Mr. Arbitrator, to quickly address your point, the answer, in short, is that the claimant is not absolved from any fault simply because the respondent had approved the EIA. This is for two reasons. The first is that the onus on creating the EIA is on the claimant's end, and Section 49 of the Environmental Act have been made known to both parties. the clear non-compliance with Section 49, which amounts to only 2 paragraphs out of missing subsections 5, 6, 7, 8, and 9, is a clear deficiency and fault on the claimant's end. And secondly, and more importantly, the claimant had also represented in clause 3.2a of the contract that to the best of its knowledge, there are no deficiencies in the environmental impact assessment study submitted. Read in totality, these tribunals should apply its mind to the fact that the claimant does have the responsibility of producing. We are not expecting a sufficient EIA, but we are expecting a non-deficient EIA. Clearly on the record, this was deficient because of the extent of the environmental damage.
So why didn't the environmental authority tell them that at that time without certifying?
Mr. Arbitrator, to quickly address this point, the reason why we could not have told them at any point does not detract from the line that we are pushing that states that this fault for not complying with the EIA still lies with the claimant. As long as the claimant is at fault, our position is that clause 7.1 cannot be triggered. This is a double line fault argument.
Can you also explain how R2, that is the Marine Environmental Protection Authority's concerns,
yes,
on the 1st of June 2024, and your suspension is on the 30th of June 2025, 1 year later. You're looking at environmental damage. For 1 year, you don't do anything. If you say the concerns were that the fault is based on this marine environmental evidence, right? So if that is so, why did you wait for 1 year?
Okay. Mr. Arbitrator.
Something related to that. Now, if you look at that letter says that they are reacting because of complaints received afterwards.
Yes.
Does that then not indicate that even they did not contemplate those issues or complaints at the time the report was submitted?
Yes.
Right. It is a subsequent discovery.
Yes.
So does that not then give credence to the position of the claimant that they did a proper study? It could not have been foreseen.
Yes, in the interest of time, Mr. President and Mr. Arbitrator, am I allowed to quickly address your question and then move on to my quick submission on damages? Now, the issue on this entire environmental impact assessment is the fact that there is a disproportionate impact on the environment. Notwithstanding the fact that these were complaints after the fact, the fundamental premise is that the claimant had represented that they had submitted a non-deficient EIA. The non-deficient EIA clearly contradicts what has happened. And in fact, Mr. President, if you say that there are indeed complaints about this EIA, that is why this suspension was enacted. And pursuant to that, the further question is that why the EIA was suspended, or rather why the contract was suspended only 1 year into after the discovery. And this was because on a basic commercial sense, I may put it to this tribunal that these land environmental impacts are due to settle down after 5 years. This was also represented by the claimant. It takes about a year, in my opinion, rather it's submitted by the respondent that it takes about a year in order to crystallize these disproportionate environmental impacts and put a halt to it. Now, to quickly canvass my second argument on damages, it is submitted in brief that clause 7.2a amounts to a penalty clause. The test for whether a clause amounts to a penalty is set out in the UK Supreme Court case of Cavendish Square Holdings and Mark Desi in 2015. Here, the clause depends on two things. First, whether or not clause 7.2 is a secondary obligation, and second, whether or not the uplift in the clause fails to represent any legitimate interest or is disproportionate to any legitimate interest of the claimant. Here, clause 7.2a of the contract is clearly a classic secondary obligation because it is a liquidated damages clause. It's a damage agreed clause. The contentious point is whether or not the uplift, the additional 15 or 25% on top of the reliance losses or on top of the wasted expenditure claimed amounts to a penalty. It is submitted by the respondent that this does.
So that means only the 15% is a penalty?
Yes, Mr. Arbitrator, it is submitted that this tribunal should strike out and sever the uplift portion only and maintain, yes.
Not the main.
Yes, if at all, the damages under the first limb of clause 7.1, which represent reliance losses, should maintain. The reason for this, the members of the tribunal, is for a very simple reason. I would like to draw a parallel to common law damages. Clause 7.2a allows effectively the claimant to claim for both reliance and expectation losses. On top of the wasted expenditure they have claimed they are able to claim another 15% on top of the reliance losses, and further claim for any de-dredging works or decommissioning works. Allow me to paint this by way of numbers. The contract price is $950 million as stated by the claimant. 65% of the contract has been completed at this present time. This amounts to $617.5 million if we assume a linear valuation. Now, 15% of the invested sum, which is the higher number between 15 and 25, 15%, which was the higher number, amounts to an additional $92.625 million on top of the reliance losses. Yet, this totals to a $710.125 million. Yet, the claimant is claiming for $850 million in their request for arbitration. This amounts to nearly a further uplift of $150 million on top of the reliance losses and on top of the further expectation losses on top of the already claimed reliance losses. Clearly, this amounts to a prima facie penal clause, simply because it places the claimant in a better position than before they had entered the contract. Therefore, it is submitted that because Clause 7.2a amounts to a penalty, this tribunal should strike out and sever the uplift portion of Clause 7.2a and confine any damages to only the reliance losses suffered by the claimant, which are represented in the first part of Clause 7.2.
I have a question there. Now, assuming
Yes.
that the termination or decision to terminate taken by the claimant is justified,
Yes, Mr.
in
Arbitrator.
terms of the contract, they are entitled to claim their investment at the time of termination. That is the $650 million, or approximately they are about that they are claiming.
Yes, Mr.
Then
Arbitrator.
that brings us to the question of consequential losses, including loss of profit.
Yes, Mr. Arbitrator.
Now, legally, if there's early termination of an expected 99-year lease period, they should be entitled to claim loss of profit. All what this clause has done is, two parties with equal bargaining power has negotiated and agreed on a liquidated methodology of calculating the loss of profit.
Yes.
So if you take the liquidated methodology out,
Yes.
and if you leave the tribunal to decide on the question of loss of profit, right, it may be more, slightly less, we don't know. I'm not doing the calculation here.
Yes.
So, which is why I'm quite at a loss to understand why you say inclusion of this methodology amounts to a penalty, and this is not a justifiable method of calculating liquidated damages.
Mr. Arbitrator and members of the tribunal, I note my time is running up. Can I quickly address your question in 2 minutes?
I had the same concern.
Yes. So there are two types of damages, members of the tribunal. The first are damages arising out of contractual damages. These are, for example, in the present case, Clause 7.2a. It's pursuant to a contractual termination. Another type of damages are common law damages. These are pursuant to a repudiatory breach that was not pleaded in oral hearings by the claimant today. To address these two in turn...
But they have taken it up in
Yes.
their...
Yes, Mr. Arbitrator, so I will address both. To address the first issue on contractual damages, the contractual agreed damages are subject to the penalty clause. This is pursuant to the Supreme Court holding case in 2015 of Cavendish Square Holdings and Mark Desi. The penalty clause then requires this tribunal to apply its mind to whether or not the uplift portion is unconscionable. This does not deal with any sort of expectation loss, but it deals with whether or not the uplift is unconscionable and disproportionate to any legitimate interest of the claimant. As submitted before, this does not apply in the present case because it is disproportionate, as previously submitted. Now, secondly, for the common law damages, only reliance losses or expectation losses can be claimed. I used that to draw this tribunal's attention to the fact that in this Clause 7.2a damages, the claimant can claim for both reliance losses and expectation losses, these which is not allowed in common law. In any case, before I conclude my submissions, it is further submitted that...
It's provided in the contract.
Yes, Mr. Arbitrator. So if it is provided in the contract under clause 7.2a, it is thus subject to the penalty rule. And then under the penalty rule, it is submitted that it is disproportionate simply because they allow the claimant to claim for both heads of damages, and in any case, it is disproportionate by the numbers I have run through the tribunal.
So you are saying it's disproportionate because it violates the common law principle?
If I draw parallels
to...
no, Mr. Arbitrator. The test is whether or not the uplift is disproportionate or unconscionable compared to any interest of the claimant. However, it is submitted that the interest of the claimant here is either its reliance losses, which is the wasted expenditure, or the future profits earned from the 99-year lease. In the present case, they are claiming for both. It is clearly disproportionate. That is the respondent's position.
If we take the fact that they can't claim for both, assuming they are claiming only for loss of profit, your position is that you are not questioning their entitlement to loss of profit, but you are saying the mechanism provided here in clause 7.1 amounts to a penalty. Is that your argument?
Mr. Arbitrator, allow me to clarify. My argument is that under clause 7.2a, the uplift portion for loss of profits or wasted expenditure, the uplift portion for loss of profits or future expected profits should be struck out because it's a penalty. But if the claimant were to run a concurrent claim or an alternative claim in common law damages, this tribunal should award only expectation losses or reliance losses. But in any case, this expectation loss is too remote and speculative, simply because this is a one-of-a-kind project with no proven track record, and the onus is on the claimant to prove said expectation losses.
Is there any authority to support your contention that you can't ask for both, other than Cavendish?
Yes, Mr. Arbitrator, I would like to point to the UK Supreme Court case of One Step Support Limited and Morris Garner, 2018. There, the court held that, first of all, the burden of proof on expectation losses lies on the claimant, and second, even if with losses were to be claimed, this would be at the expense of reliance losses. I would like to further substantiate this with Soterios Shipping and Samiet Sohot, which is a 1983 case where it was held that the claimant, if expectation losses are too remote or too speculative, this tribunal should revert to reliance losses. Now, in sum, the respondent's position is that either under clause 7.2a damages or under common law damages, the claimant should only be entitled to reliance losses and no expectation losses or any uplift.
But your classification or your statement that this clause permits them to get reliance losses and expectation losses, is it correct? Isn't it rather a clause which says that for reliance losses or expectation losses or whatever losses, you can only get the uplift and nothing more? Isn't that what it says? Isn't that really a limitation clause in one sense?
Mr. President, the test as set out in Cavendish is whether or not the uplift is unconscionable, whether or not the clause is unconscionable. In the present case, the claimant can choose between, the claimant is claiming under clause 7.2a, the damages for wasted expenditure, which is all the money they have spent on the project, and an additional 15%. Before this tribunal, it is submitted that this 15% is disproportionate and unconscionable to any legitimate interest that the claimant has. In the present case, the interest of the claimant is recovering either its wasted expenditure or claiming for loss of profits. But as I've mentioned before, because the loss of profits is speculative, this tribunal should revert to the reliance loss measure and therefore strike out the uplift portion of.
So is it your position that in a common law claim, if you're asking for loss of profits, you can't claim the expenditure incurred?
Yes, Mr. President.
You can only ask for one of those?
Yes, Mr. President.
What is your proposition for that? What is your legal proposition?
Yes,
or authority for that proposition?
Yes, Mr. President. The case was One Step Support Limited and Morris Garner, the UK Supreme Court case in 2018. There, the issue is about whether or not you can claim for both expectation losses and reliance losses. And the holding was that, first of all, for expectation losses, the burden of proof is on the claimant. Second of all, if the claimant cannot prove its burden, cannot satisfy this burden, then the court should revert to the reliance loss measure. It is essentially an either-or. If this tribunal may have no further questions.
No, we have one further question. So in 7.2a,
yes,
which portion precisely are you saying we should strike off?
Yes, Mr. President, I would request that this tribunal strike out the portion starting from including 25% of the sum yet to be invested or 15% of the total sum invested at the time of termination, whichever is higher, to represent all consequential losses, including the loss of the 99-year leasehold interest and the anticipated profit from the project. In essence, this tribunal should only uphold the part of the clause which states payment to the investor of the total sum invested in the project by the investor up to the date of suspension.
So in your submission, if you delete that, the remaining portion conforms to the common law position regarding recovery of losses. Is that your submission?
Mr. President, it is submitted that it need not necessarily conform to the common law regime of damages. But in any case, regardless of whether the claimant is awarded damages under Clause 7.2a or common law damages, it is submitted that the end state will be that the claimant will only be able to rely on reliance losses or claim for reliance losses. So, in effect, the practical effect is the same, but under Clause 7.2a, it will be pursuant to striking out the uplift portion, and under common law damages, it will be because the expectation losses are too remote and speculative. And therefore, in both cases, the claimant is only entitled to recover its reliance losses.
So the resulting position would be the claimant walks away with the 650 million money that they have put on the ground for the development and nothing more.
Yes, Mr. Arbitrator, but this is subject to the termination right, which is argued by the respondent. That's a
different issue.
Yes.
Then this your 2008 reference, what's the case?
Sorry, Mr. Arbitrator, give me a second.
Where you said...
Yes, where expectation losses are too remote and we need to rely on reliance losses. Apologies, Mr. Arbitrator, it's actually the case of Phones for You Limited and
because
EE.
Your submissions didn't talk about what you said.
Yes, Mr. Arbitrator, apologies. Allow me to substantiate orally.
Yeah.
It is the High Court case 2018 of Phones for You Limited in Administration and EE Limited.
Right.
In that case, the governing principle was laid down by Justice Andrew Barker, where a party contract terminating a contract and seeking to rely on expectation losses must prove it. If not, we must revert to the reliance loss measure. Yeah. If this tribunal has no further questions, I hereby conclude my submissions. Thank you so much for your attention.
Thank you very much. Yes, Counsel.
Members of the Tribunal, 2 points in rebuttal. The respondent spent a significant part of the submissions on the fact that the EIA was faulty and that this was ultimately the responsibility of the claimant despite the fact that they had granted this approval. They also brought up the point that the EIA is merely 2 paragraphs long and cannot have satisfied the statutory standards. However, members of the Tribunal, it is rather convenient that the extract that they are choosing to rely upon was the extract that they themselves had submitted, which is a very short extract that supports their proposition simply because it is just that, an extract that shows a small portion of the entirety of the EIA. And further, I note the Tribunal's concerns that the respondent was the one who approved the EIA, to which their only response is that ultimately the fault still lies with the claimant for having produced a deficient EIA. Importantly, the indoor management rule, as established in the Royal British Bank and Turkan, provides that a party dealing with another party in good faith is entitled to assume that the company's internal procedures have been duly complied with. And so, pursuant to that rule, the claimant was entitled to rely on the respondent's assurance that the EIA approval had been granted. Briefly, on my second point, while they raised the rule that the penalty clause applies here based on Cavendish Square Holding, the court in Cavendish Square Holding also emphasized, as pointed out by the Tribunal, that the law is slow to find a clause penal where both parties are of equal bargaining power because the clause is representative of the parties' intentions and allocation of risk. Thank you.
Members of the Tribunal, I have 3 points in rebuttal. First, regarding the respondent's rebuttal that there was there was insufficient evidence for the EIA, it is submitted before this tribunal that even if this was not the complete EIA, the EIA in and of itself submitted by the respondent is sufficient for this tribunal to find that the EIA was deficient. Again, I would like to point to Exhibit R5 of the respondent, which in the second paragraph, last line,
Page.
this respondent Exhibit R5 is on page 42.
Proceed, please.
The second paragraph and the last line states that there will be minute changes to the nature of the ocean in coastal areas. Again, this is rehashing my previous point on the disproportionate nature of what they represented and what actually happened. Clearly, this was a disproportionate impact, and therefore the EIA is deficient, and therefore the claimant is at fault for this deficiency. Now, second of all, I would also like to canvass that the respondent had the claimant had in any case failed to tender any notice, written notice of termination. They claim that they are able to terminate under clause 7.1. However, any written notice of termination was not met out. I would like to highlight to this tribunal the High Court case of Manai Investment Co. Limited and Eagle Star Life. There, the court held that conditions precedent to termination, which in this case is a written termination notice, must be complied with strictly. The test and the threshold set out in the case was so high that, and I quote, it was held that if the clause had said that notice had to be on blue paper, it would have been no use serving the notice on pink paper. That is the threshold at which a written termination notice must be served. This, therefore, evinces the principle that a valid termination notice by the claimant must convey clearly and unequivocally the decision to terminate and must comply strictly with the written termination notice. If I may turn this tribunal's attention to clause 7.1 and the right to terminate, I'd like to point to page 11. At the top of page 11, the last part of clause 7.1 states that the investor shall have the right to terminate this contract, here's the important part, with immediate effect by providing written notice to the employer. At the present case...
Can I ask you a question in relation to that? Can you please go to page 5 of the brief?
Page 5.
Paragraph 30 of the statement of claim, particularly prayer B.
Page 5, Mr. President. Yeah. Yes, I am there.
Now, if you look at that relief, the relief is a declaration relating to the right to terminate. It is not a declaration that the contract has been lawfully terminated. So in those circumstances, does the giving of a notice of termination arise? Or is it something prospective after the grant of this relief?
Yes, Mr. Arbitrator, I precisely agree with your point. In fact, the request for arbitration does not constitute a termination notice because it's merely requesting for a declaration that they have the right to terminate. And in so doing, the claimant has not exercised its right to terminate. To address Mr. Arbitrator's second point of them requesting for a right to terminate, it is submitted that this is not a matter for this tribunal to decide, precisely because it would be akin to requesting for this tribunal to be their legal counsel. They either have two routes. First, they terminate the contract and come before this tribunal to plead that the termination was valid. Or second, they do not terminate the contract and go via breach of contract, repudiatory breach. Therefore, it is submitted that in any case, Mr. President, you are right in concluding that the request for arbitration does not constitute a exercise of the right to terminate. Now, I note my time is up, and if I may just quickly have 1 minute to summarize my last rebuttal on penalty clauses. Again, it is submitted that clause 7.2a is subject to the penalty test as set out in Cavendish Square Holdings. The respondent has asserted that this uplift is because of two sophisticated companies coming together and a meeting of minds to agree to this clause. Yet, even if this were the case, the penalty doctrine still applies. When applying the penalty doctrine, again, the second limb of the test is whether or not this clause is disproportionate to any interest. As outlined before, it is submitted that the claimant cannot run away simply because they assert that we are on equal bargaining power, and the clause must still be subject to the penalty clause, and under the penalty doctrine, the clause is a penal one and should be struck out. If this tribunal may have no further questions, I hereby conclude my submissions. Thank you for your attention.
Thank you. Yeah. I think this concludes proceedings, right?
Thank you for your brilliant and well-put submissions. At this stage, we kindly request that the teams remain in the main hall while the arbitrators are escorted to the Moot Court to deliberate. Could the arbitrators, Mr. Chanaka De Silva, President's Counsel, Mr. Chandaka Jayasundar, President's Counsel, and Dr. Asanga Gunawansa, President's Counsel, kindly follow in the Ivari, who will escort you to the Moot Court.
Thank you.
Guys, so sorry to interrupt your conversations. If you all could take your seats at the table, please. The finalist teams. So after a duration of deliberation, the arbitrators will be giving simple feedback for the finalist teams to hopefully improve and carry that forward.
Okay, so very briefly, subject to what the chairman and my other colleague will say, for me, I think I was impressed with both teams, and both of you all especially handled the questions put by the tribunals very well. And that's certainly something that is very important to remember even when you guys eventually graduate and, join your respective areas of practice that you would like to engage in. One point that I would like to make is, without naming the person, one of you all, I remember when making submissions, rather than saying that I submit or I would like to bring something to the attention of the tribunal, kept on saying that, let me say this, and, I think, and so always remember, to an arbitrator or a judge, it really doesn't matter what you think or, what you tell. There's a different art and style of, putting it across. And the second point that I would like to say is that when preparing for moots, and then having drafted, several moot questions coming from, sometimes the questions are drafted or the problem is drafted to create doubts in the minds of the people who are actually preparing so that they can think about it, So there are strong points, weak points, so you have to pick them and, argue, and both the teams did that. But when you are putting across certain arguments and also relying on certain case law, in a moot, it's not up to the arbitrators to point out or disagree with the points that you are making, but make sure that it's very strong, because some of the cases that both parties cited, and I think they may not be the most relevant cases. There are other cases dealing with those points, but I didn't want to highlight that. But always remember, most arbitrators or most judges, even in moot competitions, will know some of the cases that you're citing. So to make sure that you make a very accurate reference to the cases that you can actually rely on. It's not about picking what actually suits you and disregarding what is unfavorable. It's by going, you must go with the cases which are most relevant and latest, and that should be something that be kept in mind. So that's it for me. Thank you.
Okay, it's nice to be have this finals in physical form, because online I have judged all of us the last couple on hybrid, was it last time, right? But it's not the same as seeing all doing it. As Asanga said, one thing you must remember is we only judge on your presentation. The law, as Asanga said, some were not completely relevant because of the toughness of the case. The cases are made in such a, or the moot problem is made in such a way that you feel that you have no choice in this. It's balanced a bit, but so we didn't judge you all on the law. Some of the propositions of law that were presented might not carry much weight in court, but the presentation was excellent. Thanks.
Little to add, following upon what was stated. My view is that the quality of arguments and presentation was very, very good, extremely good. I was very impressed with the manner in which the questions were handled, because at the end of the day, you come prepared for the presentations. So you have enough of time to prepare. You actually prepare well. So therefore, your presentations are expected to be good. We did expect it to be good. And I think you perhaps did better than what we expected. But at the same time, I think I was very impressed by the manner in which you all handled the questions. And many of those questions probably would have been difficult even for a normal practitioner. Even if those questions were asked from us, we might take a little bit of time to respond to them and think about them. But the way you all approached them and the way you all responded to them were extremely good from both parties. But at the end of the day, there were little nuances in the manner in which everybody approached things and how everybody is, how shall I say, tested in accordance with the scheme. So that will result in certain sequences and so on. But I must congratulate everybody on the excellent manner in which they responded to the questions. Right, great. And the only thing that you must remember as you go forward is, right, like Asanga and Chandaka said, you are getting ready for practice, right? So when you make a legal argument, when you make a legal proposition, please take time to ensure that the proposition that you're making or presenting is sustainable, right? And is well based on a legal principle. Don't overstretch it, right? You can make the argument, but you will not win the argument. We make the arguments for the purpose of winning when we are actually presenting the cases. So always remember that. Get used to that even in a moot, right? So although the argument is feasible, where does it take us? Is a question that you always need to keep in mind. So thank you very much and all the best for the future. Yeah. And we enjoyed participating in this.
With that, we have come to the conclusion of the final round of the 9th Victor's Moot. We'd like to gleefully thank the arbitrators for their feedback and for taking time off their busy schedules to be here and judge the final round. I would like to kindly request the team remain on stage while the arbitrators make their way outside of the hall.